Ed Nisqually, your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Buckle up, guys. Today we are going to watch how fast confidence collapses in a real courtroom. The defendant opens with the classic sovereign script, insisting he's an agent and not the person named on the case. The judge doesn't entertain the wordplay for even a second. He forces the record straight and makes it clear that labels don't erase responsibility. Right here, the court establishes dominance, and the fantasy starts cracking.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people.
All right, guys, this part shifts from identity games to raw facts. The officer's report comes in, laying out exactly what happened at the store. Intoxication, refusal to leave, and repeated warnings ignored. The defendant's own words, claiming he was too drunk to be accountable, end up doing more damage than help. Now, this is where the case stops being theoretical and becomes painfully real.
So, for the record, that's my finding. Yeah, hold on, we're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony, probable cause application will be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he...
All right, guys. Now the judge pivots to the bigger risk hiding behind this charge. A new violation means an old case is suddenly back on the table. The defendant doesn't seem to grasp how quickly things can spiral. You can feel the tension rise as the court explains that this isn't just one mistake. It's a trigger for much worse consequences.
That he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable, Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton, that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Squally jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault
Honor.
case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
Here comes the warning most people ignore. The judge explains calmly but firmly why representing yourself is almost always a terrible idea. No coaching, no shortcuts, no mercy for mistakes. The defendant hears all of it and still chooses pro se, mistaking defiance for confidence. This decision quietly sets the tone for everything that follows.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will, and Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information.
Hi, watch how fast theory crashes into reality. The defendant can't even name the proper legal terms and openly admits he's guessing. The judge allows it, but you can tell the patience is procedural, not personal. The court moves forward, knowing the defendant is walking into legal quicksand on his own.
Assist you in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even though the right term. Okay. All right. I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cam.
All right, guys, now we hit the Miranda confusion. The defendant treats Miranda rights like a shield that should stop the entire case. The judge explains that Miranda limits statements, not arrests. And this misunderstanding is fatal. This is the moment every lawyer watching knows exactly where this is going. And it's not good.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court
Read
order.
your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it. And then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
All right, guys, this part is pure courtroom control. The defendant keeps interrupting, circling the same arguments and resisting direction. And the judge forces him to read the rights form on the record, slowing everything down to restore order. You can hear frustration on one side and quiet authority on the other.
All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so with the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man.
All right, guys. Now comes the critical moment. Bond arguments. The judge gives a clear warning. Talk only about release, nothing else. The defendant ignores it and rambles about unrelated claims and past grievances. This is his one chance, and he burns it in real time.
Standing warrant out of Skagit County. I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
You know, if the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
All right, guys. This is where consequences land. The judge explains Miranda correctly, dismantles the confusion, and confirms the defendant still wants to represent himself. Even the judge's sarcasm slips through here, signaling how far off track this has gone. The bond is set, conditions are imposed, and the door closes.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't know whether that
Well, I have
changes anything.
$100. Isn't that
Okay. All right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail. So you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right. I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking of, by the way,
Mr. Sharp has heard you, and we'll go
On
forward that
on
way.
a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
All right, we got that.
Yep, appreciate you.
All right. Thank you. And we'll see you on the 24th.
All right, guys. This final part seals the lesson. The defendant struggles to understand basic bond math and asks for privileges the court doesn't control. The judge schedules the next hearing and shuts down the remaining side arguments. This is what happens when ego replaces preparation. Like the video and subscribe to the channel, and we'll see you in the next video.